Ah,
Yes, yes. Now I'm starting the class of this remedial class of law of tort. The people, those who are failed, are they going to return for the going to write? Rather, I could use the word on the 27th September 2021. And yesterday that we discussed about the general defenses. Also, we completed over there. Then the demnum sine injuria, injuria sine demnum, and in this class we will know. In the yesterday class that we dealt about the receptional equitard, that is the wording that we used over there. And then the differences between the law of tort and law of crimes and law of tort and law of contract, this was the we dealt it. And in this class, and we would like to deal the two injurias, that is a demnum sine injuria and a injuria sine demnum. Yes, these are the things. Yes, anyone can unmute and read what I put on the screen. Yes.
Sir, good evening, sir.
Good evening.
World Bamboo
Please.
Day, 18th September 2021. Benefits of miracle plants, bamboo. Needs
Okay.
to know pesticides or synthetic fertilizers spreads quickly and can be harvested in three to five cyclones. Rarely needs replanting. Generates more oxygen than trees presents.
Okay.
An essential role in the stability of oxygen and carbon dioxide in the environment.
Okay.
Uh, Separates carbon dioxide and is carbon neutral, needs no irrigation. It is great for hindering soil erosion. Its creation into fibrous has a lower environmental influence than other kinds of fiber, particularly artificial ones. Edible, biofuel, flexible, is strong joints the soil. Bamboo is uniquely tall, used to promote fertility in cows, used for scaffolding. Professor
Yes.
Dr. Mohammed Saheb Hussain, sir.
The purpose of making the thing is the importance of the bamboo is stated over there in this. And today is the World Bamboo Day. And here the one thing we would like to know it there. The bamboo tree will produce the more oxygen than a tree. That is a very important factor. The essential role in the stability of the oxygen and carbon dioxide in the environment is then it generates the more oxygen than the tree. That is another point. Then the another unique point is there. It is uniquely tall, number one, and used to promote fertility in the cows. So it promotes the fertility in the cows means suppose if these leaves are taken over, eaten away there, then the fertility is more in the cows. And I don't know whether you know the scaffolding. Yes, if you know it, you tell me. If you don't know, you can say pass on. Scaffolding.
Sir, passed on, sir.
Yes, when the mason, they are constructing the big, what I say, walls, they will stand on the scaffolding and they will use the bricks and cement and plastering. That is called scaffolding. It is made with the bamboo, a bamboo platform, rather we can say. A bamboo platform is said to be the scaffolding. Is it clear?
Yes, sir.
Yes. See, the purpose of my giving is one should have to know the importance of the day also. That's my intention. Yes. Now let us come to the our original the demnum sine injury and injuria sine demnum. And you be just be reading. These are the things generally that we will be asking the short questions or the long questions. In sometimes, yeah, it can be asked in the both the ways also. Rather, I could use in that manner. So demnum sine injuria and an injuria sine demnum is concerned. Then when in navigation flow, it is like that. We will see the introduction, we will see that is definitions, we will see it's what how it can be applicable with the decided case class. Demnum means damage. Sine means without. Injuria means legal injury. That is the actually the demnum sine injuria is the difference between them. Already I told you that navigation, the law of tort is the assembly of all the situations where the court provides a remedy for the way of damages. The reason is if any damage is caused to a person, then the damage should be compensated. Now the question comes, what type of the damage should be compensated? Whether legal damage or a moral damage or ethical damage? Then the question comes, a legal damage can be compensated. So legally unfair harm or injury done by one to another person, and if such a thing is there, that should be compensated. What are the three basic elements which need to be proved before the constituting a tort? Number one, there must be an act or omission on the part of the defendant. A defendant has the duty to act on it. That is the number one. Number two, the act or omission should be in a violation of the legal right vested in the plaintiff. So a legal right will be vested on the plaintiff, and simultaneously, in the opposite manner, a duty will be imposed on the defendant. Number third, the wrongful act or omission thus done by the defendant is of such a nature to give rise to a legal remedy. So such a wrong or harm caused to the plaintiff could give rise to the such a legal remedy, and where a person can go to the court of law and file a case against the defendant. So both the maxims are divided in three parts of it. One is the deminum, I told you damage. That means substantial loss or damage with respect to the money or health or convenience, whatever it may be there. It can be either mental harm or bodily harm in any manner, that is a damage. Injuria means, or injuria or injuria, spelling is INJURIA, means an infringement of a right given by the law to the plaintiff. So that right will be given by the law or operation of the law by the plaintiff, and that is not the moral rights again. There, I told you already. And a sign means without. So this is the synthesis of that maxim. And these two maxims fall under the category of the qualified right. And in the case of the qualified rights, there is no presumption of the damages, or the violation of such right is actionable only on the proof of damages. Then the question comes over there. Whether it is actionable per se or not is another question. No, it is depend upon when the legal damage is made over there, then only that the damages will be awarded. Now let us see the deminum sign injuria. There is a damage without legal injury. So there is no legal injury is there. So such a damage we will see. And the general principle on which this maxim is based upon is that one exercise the common and his common or ordinary rights. If any common or ordinary rights are there within a reasonable limit and without infringing others' legal right, such an exercise does not give rise to an action in tort. So, if there is no legal injury would be there, then this maxim will not be applied. The damages can be of any form, either in the form of any substantial harm suffered, or from respect of the money, or comfort, or health, etc. So let us see how this maxim will be applicable. So there is a classical case law. The remarkable case law is Mayer and Company of Bradford versus Pickles. Rather, we can say Mayor of Bradford Company versus Pickles is the landmark case law, and in which the corporation of the Bradford filed a suit against the defendant, alleging that the act of the defendant by digging a well in the adjoining land owned by the defendant has cut the underground supply of the water in the corporation's well, hence causing them monetary and losses, since there was no adequate supply of the water to discharge for the people living under the jurisdiction of the corporation. So it was held that the defendant is not liable, since they had not violated any legal right of the plaintiff. Why the legal right is not violated over here means he dug a well in his own land. That means he is having such a right. Of course, there is a caused damage to the corporation, because the percolation of the water from this plaintiff going to the defendant will be curtailed or stopped, because most of the water, because of the fountain, the inner fountain, water fountain or water strata would be in their well only, because he dug it in a in the deep manner. So the water strata flowing from his land to the Bradford land would not be done, because would be stopped over there. Whether I can use the word. So there is a substantial damage is happened to the mayor of Bradford, because they could not supply the water to the people. And even though there is a supply of the water, the substantial damage happened over there, but still there is no legal injuries caused over there, because the plaintiff dug his well in depth in his own land, which he is having every right to do so. Of course, now I think the central government also keeping on the borewell some cess. Just today it is viral in the WhatsApp. I don't know whether you saw it or not. Moreover, one should not make the borewell in his own land which is unnecessarily. Suppose, can a person for the domestic use could use the 4 borewells? Answer, please. Unmute and give the answer.
No, sir. Only one borewell, sir.
They are not supposed to do it. And moreover, the size of the borewell in the houses is entirely different from the size of the bore which is there in the fields, in the agriculture. Household is small and agriculture is a big bit. So that is the number one case law where there is a damage is there, but there is no legal injuries caused, or and hence the defendant could not be the defendant could not be held liable. That means plaintiff could not get any other thing. In the same way, that is another case law is there, which is the famous case law, the Gloucester Grammar School case law. And here, the schoolmaster set up a rival school to that of the plaintiff. And since because of the competition, the plaintiff had to reduce their fee from the 40 pence to the 12 pence per quarter. So that he reduced the fee and kept a good infrastructure and kept a very intelligent and highly talented and beautiful and handsome teaching staff over there. And thus the claimed for the compensation, because most of the students, they took the TC from that school and came to the new school, which is a rival, which started very opposite to that school, and hence there is a substantial damage of the revenue would be there for the former school. And he filed a case against the person who has opened a new school for the damages. So thus the claim for the compensation from the defendant for the losses suffered, because a lot of the students have left the college and he lost the revenue also. It was held that the plaintiff has no remedy, because for the losses suffered, since the act, through morally wrong, has not violated any legal right of the plaintiff, because generally the competition is allowed in the market. So if you give the good facility, naturally the people will tend to come to you. If you give the worst facility, they try to stop it and seek the alternative. So that was the thing would be there. And so competition is allowed over there. There is a low legal injury, even though there is a substantial damage caused to him, because most of the students left the college and joined in another college. The revenue is lost over there. Even in spite of that also, there is no legal injuries caused. Hence, this deminum sine injuria is there. That is, defendant is not liable. Then another is Chesmore versus Richards. In this case, plaintiff places located a lower elevation of the respondent was a higher elevation. So lower elevation, higher elevation, in the sense, naturally the water flows down to the lower elevation. So the defendant, by the constructing a well on his own land, blocked the underground water supply to the plaintiff mill, thereby resulting the monetary loss to the plaintiff. Naturally, suppose if he dug it in the more depth manner, naturally the water will not flow to the lower area, because he dug it mostly. However, the court held the rule that hence the absence of the infringement of the legal right of the plaintiff, no legal remedy would be accrued to the plaintiff, because he dug it in his own land, that he is having a right. There is no legal injuries there. There is no infringement of the right, even though the substantial damage is caused. But still, the defendant is not liable. The plaintiff is not going to get any damages. Yes, can anybody will unmute and read this case law, Usha Ben versus Bhagyalakshmi Chitra Mandir? Yes. Unmute and read.
Sir, Usha Bhavan versus Bhagyalakshmi Chitra Mandir. In this case, the plaintiff alleged that continued sounds of religious invocation hurt her religious sentiments, and thus prayed for a legal injunction. The court concluded that any hurt to religious feelings cannot constitute as violation of legal right, and so the plea of the plaintiff was denied, sir.
Yes. See, the plea of the plaintiff is denied because in this Bhagalakshmi Chitra Mandir, they are the producer. They produce the movie that who are the three goddesses, who are the wives of the Lord Shiva, Lord Vishnu, Lord Brahma. Is it Brahma?
Yes, sir. Lakshmi, Saraswati.
Yes. Parvati, Lakshmi, and Saraswati. Is it?
Right, sir. Right, sir. Yes, sir.
So the three will be shown in the movie having the jealousy to each other. So that is picturized in the movie. So some of them who saw that movie, they said, no, because they are picturized in such a way. But he said, there is a little jealousy would be there in the among the three in some respect that he is shown over there. But he did it. Suppose if you are feeling that there is a religious feeling would be there for you who are going to be hurt to you, you need not to see that movie. But there is no such a legal injury is caused over there, because whatever the it is in the mythology is there, that is synchronized in the movie, not exaggeration, not an exaggeration that made it over there. And hence, there is no legal injuries caused over there. And whatever the characteristic, the role played by the three goddesses will be picturized over there. And hence, it is not about the legal injury. It is even though substantial damages happen to you because your religious feelings were hurt over there. And that is the reason they can make it out. But one thing really it is hurt and causing a public nuisance would be there at the time, definitely. Then it is a legal injury is caused, we can say. Like that satanic verses written by, yes, Salman Rushdie. Lajja written by
Yes, sir.
the Bangladesh lady. What is her name?
Taslima, sir.
Yes, Taslima. So these are the
Yeah.
certain books are banned over there because it causes a havoc in the public, and hence the government will take such a. Even though we have had the case law ones also in the IPC, you read it. Ladies Chartlier Lovers, that is also a book which is banned over there. Then the person is selling, he will be held liable even though he doesn't know what is the content of the book, because they said it. They said there is some pornography would be there in that book. That's why that is banned in India. Okay, another case like the action versus bundle. In this case, the plaintiff was lawfully carrying on a mining operation on his own land and was unknowingly led to the draining of the water kept in the plaintiff land. The plaintiff had filed a suit bringing about the action for the damages. The court ruled that since the action of the defendant was lawfully justified and did not lead to the infringement of the right to the plaintiff, hence no action for damages. Again, the same water flow. Again, the same water flow would be there, where the strata, where naturally the water will flow down. Suppose if you dig it too much, then water will come to your well and in your land only, and the adjacent person, those who are there in the, then if you lose the water, at that instance, we can say that he dug his well, he made the deep end his well in his own land, but he did not infringe somebody's right, and hence demnem sine injuria is applicable over there. So these are the cases where we can say number action versus bundle case law, Usha Ben versus Bhagyalakshmi Chitra Mandir, and Cheshmore versus Richards, and Gloucester Grammar School case law, then Mayor of Bradford Company versus Pickles. So these are the generally the case laws would be there. When it is asked in the long question, at least you can cite 3 to 4 case laws, then the examiner will be inflated and give the good marks to you, because tort law is nothing but the product of the case law. Repeat. Say again.
Tort law is a not exist.
Tort law is nothing but the product of the case law. Okay. Now let us see that what is the injuria sine deminum or demino. Injuria sine demino. INJURIA, injuria or injuria. Sine, 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 demno, DAMNO, demno. Injuria sine demno is a violation of the legal right. Here the legal right is infringed without causing any harm. Harm is not caused over there. Or loss is not caused over there. Damage is not caused to the plaintiff. Wherever any legal right is infringed, the person is whom the right is vested in the entitled to bring an action. Suppose somebody spit on your face, even though there is no damage caused over there, but again he has given the towel to you to wipe it out. Can he does so? Answer is yes or no. Yes.
Without damage, sir. So,
Spitting, ummi evadam.
oh yes, sir.
Suppose
That is the
somebody spit
damage,
over
sir.
you and gave a towel to wipe it out. One
That
cannot
is
do such a
damage, sir.
thing. It is nothing but a one way in another way is a battery. Is a
Oh,
trespass to person.
yes, sir.
Somebody's land, you are not supposed to enter in it. Sir, if that fellow is a beggar, Okay, if the beggar is there, he should stand in front of the gate, then he have to beg from there. Sir, the distance is very more. He doesn't have the microphone to say. If the door is not locked, okay, he can open it and come inside. But another thing also there, but still he can be called a trespasser. But his intention is not to steal the any article, but intention may change also if you could see any article very in the vicinity of the place. So now the question comes over there. Of course, the exception is beggars. Of course, no beggar will such beg in any other country. In general, I am speaking. If they want to beg, they just stand roadside along the roadside and stretch some a paper or a towel or any kerchief so that the people, those who could pass by, they will just donate the alms over there. But anyway, the point is, every person has an absolute right to his property. He can defend his property, he can defend his prestige, he can defend his name and fame, and all this is there. And infringement of right is actionable person. Suppose if there is an infringement is there caused over there, even though there is no substantial damage is caused over there, but still, when a legal injury is caused over there, then naturally he should be or she should be compensated. A person against whom the legal right has been infringed has a cause of action such that even a violation of any legal right, knowingly bringing the action, cause of action. Either knowingly or unknowingly, it doesn't matter. If any legal injury is there, it is enough. A person will get the compensation. Now let us see the what is suit under the provision of specific relief act under the declaration of the injunctions. Of course, sometimes no, they will say the specific relief act specific performance should be done, and sometimes an injunction will be issued also. That is also one of the remedy in addition to the compensation. Let us see an example. If a person is wrongfully detained against his will, he will have a claim for the substantial damage for the wrongful imprisonment, even if no consequential loss has suffered or none the detention. On the detention, suffered on the detention. Yes, suppose somebody detained you. Of course, you are not going to lose it because he detained you and he kept it in the AC room and arranged some beautiful dishes for to eat and entertainment for the TV also. But still, it is amount to detention because when you want to go out, you will not be allowed to go out. Without any reasonable cause, nobody could detain you. At that instance, even though there is a substantial damage in has caused over there, moreover that you enjoyed the AC, you enjoyed the dishes served over there, you enjoyed the TV, you enjoyed the newspaper, everything, but still it is about to detention, and such a detention, whether you have the knowledge or you don't have the knowledge, in some cases, now the present case law also like that, if you don't have the knowledge also, if you know later on that you are detained, naturally you will be entitled to get the damages. So let us see that how this legal injury is caused without any substantial damage would be there in the cases. Then the remarkable case law is Ashby versus White case law. That is the election officer and he wants to go to for the polling and the presiding officer will not allow him because he said your name is not over there, but he referred the old voter list. But anyway, that he was not allowed to cast his vote. But in spite of that also, when the result has come, that fellow that whom that he would like to vote, he won with the bumper majority, and substantial damage is not caused over there. But still, there is a legal injury is there because he is having a right to vote, which is not allowed by the presiding officer to franchise his vote, to cast his vote. There is a legal injury, hence compensation should be paid. Is it clear?
Yes, sir.
Very good, very good. Otherwise, I don't know whether you are hearing me or you are not hearing me. Yeah, I did not come across it unless until I will check once whether you are hearing me or not. Yes, that is the Ashby versus White case law that I made very much clear. That comes under the injurious sine demonum. Then another applicability of the trespass was observed in the case of the Sain Das Ujagar Singh. The denominal damages are usually avoided for the principle of injurious and is applicable to an immobile property where there has been an unjustified intrusion on the property position of another. Suppose it is your own property is there. At that own property, nobody should enter into that property without the consent of the owner. If anybody enters in it, that's amount of trespass, sir. Even though the property, there is no damage is caused over there, but still the legal right of a person that not to be entered in that premises without his consent is infringed. Hence, trespasser has to pay the compensation, being trespassed in the property, or if it is a personal thing, he trespassed in the personal. Even what I say, hacking your email also a trespass. Are you following me?
Yes, sir. Hacking
Or
the
hacking
email
your
also.
account also a trespass.
So, sir, I think so. That is a cyber crime, sir.
Yes, yes, yes. That is a new name is given is a cybercrime. That is because it
Cyber
is
crime.
done with the electronic system. So we can say the cybercrime is there, and that is a way one stalking, spatting, and these are all comes under the bullying. These are all comes under the
Yes,
cybercrimes. And
okay.
at that instance, suppose somebody kept your stolen your photo and used it for some different purposes, then at the time also the trespass to person we can say, and that also a cyber crime where a person will not supposed to do because your legal injury is caused over there. Even if suppose somebody is take your photograph without your consent, it is also a trespass. It is also a trespass to person, we can say it, and it is a crime also. And nobody would keep the photograph. Even a photographer in the photograph shop, suppose if he wants to keep the photograph to show to the public the size of the photos, at that instance he has to take the consent of the people, then only he can display the photograph in the studio. Are you following me?
Yes, sir.
Yes, sir. Now let us see that what the case law is there. If you without any permission, if you done so, then it is amount to the legal injury, even though there is no substantial damage caused over there. Suppose, suppose somebody winks at you. Is it amount to a offense? Answer is yes. Even though there is no substantial damage over there, but he is passing a wrong signal, an obscene signal to another, is amount to the offense committed by that. Even though there is no substantial damage caused over there, there is a legal injuries happened over there. Even a flying kiss, if it is a flying kiss made and towards a particular person, then it is passing obscene, what is the gestations or signals, then it is also able to the injury or cyanide ammonium, where the damages will be awarded over there. Yes, let us see the one Ashrafi Lal versus Municipal Corporation of Agra. This is also same like the Tashbi versus White case law, and here the voter's name was dropped from the electoral list for the local municipality election, due to which he was deprived from the exercising the legal right to vote. Consequently, he brought about a plaint for the damages, a demand of the compensation from the Municipal Corporation of the Agra, and for the violation of his legal right. This the court citing the HB versus White case law and awarded the nominal damages to the plaintiff because there is a legal infringement was there, and he was supposed to vote, but he was not allowed to vote over there, and hence his legal injury is caused, even though there is no substantial damage is caused, but still that a compensation would be paid. That is the thing. Then the maximum injurious and demeanor refers to the remedies which are provided in the form of the damages or compensation in violation of any legal right, such that if the form of the legal right is violated, then the action lies. Then if there is no harm to another, in other words, it is an infringement itself is enough. There is no loss is suffered, and but creates a cause of action. Suppose somebody used తిట్టిండు అనుకోండి ఎవరికన్నా, even though there is no loss it be there, but still it is an insult, it is a defamation. So it is it is a infringement of the
Legal, sir. Legal right.
legal right. That is the idea. So let us see the one case law, Marzetti versus Williams. The case law, let us see. The plaintiff wanted to withdraw from his bank account using the check. Okay, he want to use the by withdrawal form also we can use it, or checkbook also we can use it. However, he was prevented from doing so by the bank manager. Even though he is having a lot of fund in the bank, amount in the bank, but the bank manager stopped him to withdraw. And as a result, the petitioner filed a suit for damages on account of the infringement of his legal right, because it is his money, and he is having every right to draw it where the manager will not stop him, unless until if the signature is not tallied, at the time the manager can stop. If the rewriting is there, okay, he'll ask him to sign over there. If the signature will not tally with their own signature, again he will make the affidavit and ask the other person whether you are the same person, because earlier your signature was different, but the age is going on, that your signature is changed over there. Then again he will take the three specimens signature, latest signatures, and that will be used over there if you really you are the owner of the account. You are the owner or account holder. So the court recognized that the manager's conduct preventing a plaintiff from the money from his own account, even where there was sufficient money without any overdraft charges, was a violation of the legal right of the plaintiff and liable to be compensated. Suppose in sometimes the overdraft also be allowed over there. Suppose it is the discretion of the account holder, no, not account holder, the manager, and the nature of the account also. If the terms and conditions are lower over there, of course the manager is having every right to either allow or not to allow. So when a really your legal infringement is there, and you have the sufficient amount in your bank, and the signature is tallied, and you're a genuine person, but still the manager is stopped, it means is a legal injury is caused. At that instance, even the manager will be held liable. And the defamation that we will study it, suppose if to the customer, it is one of the, I think it is SBA case law, I think, or one of the case law that we studied over there, where a bank staff said to the client, customer, you are a prostitute, because she is a lady customer. Even that is enough. That is enough. It is amount to a defamation, and
Yes, sir.
the bank would be held liable to pay the compensation under the vicarious liability. Because in the bank premises, she used the word, the staff used the word, and to say the customer that you are a prostitute. You are not supposed to say, even a prostitute also comes to your bank and make the transaction, because you are not having any right to say so, because if you say so means you have some grudges over her, or her income is more than you. Perhaps that is one of the grudge. So what I want to say is, if any person is a legal right is violated over there, even though there is no substantial damage is caused, but still injuria sine damnum is applicable over there. A legal injury is caused and without any damage. Now let us see the differences between the damnum sine injuria and injuria sine damnum. So, damnum sine injuria number one. Damnum sine injuria refers to the damages suffered by the plaintiff. No damage is being caused to the legal right, as there is no violation of it. So, when the legal right is violated, then damages should be there. But only damages are there, but no legal right is violated, is a damnum sine injuria. Comes to the injuria sine damnum. Injuria sine damnum is a legal injury is caused, legal infringement is caused to the plaintiff without any damage to the physical injury. Of course, there is no damage is happened, but there is a legal injury is happened in the injuria sine damnum. At the time, yes, it is applicable. Number two, it is a losses suffered without the infringement of any legal right, hence creating no cause of action. If the legal right is not violated over there, but the substantial damage is caused over there in the damnum sine injuria, one cannot get it. But here, in the injuria sine damnum, the right hand side, it is an infringement of a legal right, and where if no loss has been suffered by the plaintiff, still creates an action, cause of action. Of course, తిట్టినంత మాత్రాన ఇది ఏమైనా ఒరిగిందా, people say. But it says we are not supposed to use such an obscene language in the public, because it lowers down the other person's image, even though nothing is there. Okay, I used one language, Titu. You used two. Can you say so? Answer no. So, infringement is very important factor in the second one. Number third, no compensation in the form of damages is awarded by the court, because there is no legal injury in the damnum sine injuria, and hence no damages will be awarded over there. But when the injuria sine damnum, there is a legal injury is caused over there, even though there is no damages happened, but still a person gets the compensation. How much compensation depends upon the how much that he suffered, mentally suffered, bodily suffered, or both the way that he suffered. So that will be counted over there. Is it clear?
Yes, sir.
Can anyone will unmute and read number 4?
Sir,
Yes.
I will read, sir. I will read, sir.
Yes, go.
The fourth one, sir. This maximum is for the moral wrongs which have no action in the eyes of the law. This is the damnum sign
Sign injury.
injuria side, sir. Yes, sir. This one is an injurious sign damnum, sir. This maximum is for the legal wrongs which are actionable if the person's legal right has been violated, sir.
Yes. So in the left hand side, they say the maximum for the moral wrongs which are no action. The moral wrongs are there, no action in the IF law. But in the right hand side, the maximum for the legal wrongs which are acceptable, actionable if the person's legal right has been violated. That is the right hand side. Now let us see the fifth one. The principle of this maxim is that a person exercised in such a manner within a reasonable limit which does not ground action in tort merely because it causes damage to the people. See the point again that comes over here. See, even though there is no legal infringement and the substantial damage caused or a little damage is also caused, it doesn't make any difference. There is no compensation will be paid over there. But one thing is very much clear. Suppose that with a bad intention, if he did it, is sometimes in the law of tort they will take into consideration. If a person has made a bad intention, at that instance, yesterday class I told you, Hollywood Silver Fox versus Emmett. In that case law, he is using the fire guns with a bad intention to cause the victims not to meet. So that was the reason sometimes it will be taken into consideration. The fifth one, the right hand side is the principle of this maxim is that whenever there is an invasion of legal right, invasion of legal right means nothing but infringement of legal right or violation of the legal right. There creates a cause of action that even there is infringement of legal right that they create a cause of action and the person whose right is vested is entitled to bring an action. A person who suffered such a thing, he is entitled to bring an action in the right hand side. That is a sign, injuria sine devinum. Okay, let us see the sixth point in the left hand side. In this, the plaintiff suffers a loss, but he has suffered no legal injury. I already told you that even though he suffered the loss, but there is no legal injury in the left hand side, right hand side, injuria sine devinum. In this, the plaintiff suffers a legal injury and does not matter they have suffered any loss or on that account or not. Even though he suffered the substantial damage or not, it doesn't matter where there is a legal injury is there or not. That is very important factor. Okay, let us see the next. Yes, sixth.
Damage.
No, sixth we read it just now. The seventh, damages without injury are not actionable. There is no injury at all in the left hand side, not actionable. This is the actionable since there is a violation of the legal right is there in the right hand side. But we want to make a distinction, try to make each point as a separate distinction so that the number of points will be increased. When the number of points will be increased naturally, the examiner will be inflated and give you, even the short questions are there, 5 marks are there. Let you presume he will give 5 out of 5. But such a thing you could not get it in the essay type questions. Am I right?
Yes, sir.
Yes. Suppose the essay type question is 20. You write it so much good also. Very rarely that you will get the 20 by 20. But if you write the short questions, you will get 5 out of 5. Because nothing is there to write more than that. Okay, some of the cases also here given in the Deminum Sine Injuria, where the Mughal Steamship Company Limited versus McGregor Government Company. And this is the case law where it is say competition is always allowed over there. When competition is allowed over there, somebody will give the charges, cargo charges, he will make it less also. The other people who suffered it, let him suffer because there is no legal injury, even though substantial damage is caused to him. A person who is having a good stand, he will survive over there, otherwise, he will sell the company. So that is the thing happened in the Mughal Steam Company Limited versus McGregor Go and Company because another company has kept the charges very low for the freight. With that, the other company got suffered a lot. But competition is allowed in the, of course, not unfair. Fair competition is allowed over there, and hence it is not amount to the injury. It is only the demnum sine injury. Damage is caused without legal injury. That is happened in the McGregor Gowan Company case law. Of course, here they have given, yes, the case law, same case law, and he made, okay. Now let us see the another case law. This is also we taught when we were teaching for the law of tort. That is the Bhim Singh versus State of Jammu and Kashmir. If anyone having any idea regarding this case law, he is
Yes, sir.
MLA
He,
and he
he
is
is
not
an
allowed.
MLA, sir.
Yes,
He is not allowed in the parliamentary, sir. At that time, the policeman stopped him,
assembly,
sir.
assembly, not
Afterwards,
parliament, assembly.
assembly, sir. Okay, sir. Jammu and Kashmir. Okay, sir. The next, the policeman custody, sir. Afterwards,
Yes,
he sued
released.
on the, yes, sir. After he released, sir, uh, uh, he is at that time he is in a voting period, sir. So,
Yes.
but uh, he is not allowed
That
inside,
fellow
sir.
lose the, he lose the chance to vote in the assembly sessions. He got the chance to actually to hear either to support it to deny it, but he lost such a chance.
He lost his vote, sir.
Yeah, yeah, and moreover, his liberty is curtailed. It's a false imprisonment without a reasonable cause, without justification. No policeman can arrest any person or detain any person without showing the reason. So here
Yes, sir.
that Bhim Singh, the poor fellow, is put it under the police custody. He was not allowed to go to the assembly sessions. And next day that he released him, not next day, I believe that in the same evening or that. On the same evening, I
Same,
believe
sir.
that he is released over there. But the Bhim Singh that without any justification they detained me, and hence my Article 21 is curtailed over there. My liberty is curtailed over there, and it's a false imprisonment they made me. They did not allow me to go anywhere. I was incarnate, and hence he filed a case against the state of Jammu and Kashmir, and the state of Jammu and Kashmir is held liable to pay the compensation to the Bhim Singh. That is the exemplary damages. 50,000 is awarded to him.
50,000, sir. 50,000, sir.
It is an exemplary damages are awarded to him, so that the state cannot make the high-handedness to detain any person by using their power, the state power. So exemplary damages in the form of the punitive damages they made the state, and state should be not supposed to do in such a way. Of course, the vicarious liability will come into the picture, and the state should have to pay it. Whether the policeman who handled him, whether he will be liable or not, that is a different issue. The first and foremost, the state should come to the rescue of the people. Later on, that other things can be done. So that is a very remarkable case law, which I said he was arrested, was not even presented before the court for the 4 days. The habeas corpus petition that he filed, and he said no, the arrested was not even presented before the court for 4 days. Oh, the 4 days that fellow would be there and was kept in the hidden place. And the case is all about the violation of the personal liberty, where the police, through the obtaining a remand of the arrested person, yes, not producing before the magistrate within the requisite period. What is the requisite period to present before the magistrate? Anyone?
24 hours, sir.
24 hours that you have to register, he should be present to the nearest police station. But the police people are so, what do you say, intelligent. They will arrest in the evening of the Saturday so that that fellow would be there on a Sunday. Again, they will be produced on a Monday. Are you following me?
Yes, yes, sir.
So there was a gross negligence, a violation on the part of the police department. They violated the Article 21 and Article 22 of the Constitution of India, and the 50,000 damages are awarded to the Bhim Singh because it is purely the case of injuria sine demonum. It is purely the
Yes,
case of
sir.
injuria sine demonum, and the legal injury is caused over there. Yes, still 5 minutes are left, and I would like to complete the UB just EB remedium also if possible, because it is a small topic. So the conclusion of the two maxims are such that the immoral wrongs one cannot get any compensation, and only the legal wrongs one can get the compensation. Whether there is substantial damage happened or may not happen, the legal injury is there, you will get the compensation. But the substantial damage happened when there is no legal injury, nothing will be going to get it. That is the gist of this demnum sine injury and injuria sine demnum. Then the last topic that he said, could you read what I posted on the screen? Yes.
Sir, P and B, associate to LLP, advocates and legal consultants, UBJS EB Remedium, legal
Yes, it
maximum,
is a
sir.
UB just EB remedium legal magazine. It is means where there is a wrong, there is a remedy. Because all wrongs goes with the remedy. So here they say right to a remedy includes a right of action. The maxim also states that the person whose right has been infringed has the right to enforce the infringed right through any action before the court. So here applicability of this maxim is to be applicable where there is a right which is recognized by the law. Yes, not moral right. And recognized by the law. Number two, the wrong act which violates the legal rights of the person. Number two. That is number three, to be applicable when sufficient relief has not been provided by the court. Number three. Number four, to be applicable if there is a legal injury. Yes, if there is a legal injury, only that will become so. Of course, there is the exception, they made it to there to moral and political wrongs which are not actionable. Yes, only legal wrong will be actionable. To a breach of a marriage owes a personal commitment without consideration. Suppose the breach of marriage would be there. Of course, you will suppose if you spend a lot of money in the engagement, that amount will be paid back. But we cannot make the specific performance of the contract in the marriages. Next, to those who don't have the legal damage, if there should be a legal damage should be happened over there, then only this maxim could be applicable over there. Now let us see the illustration. What illustration would be there? Here, a a clock tower, a clock tower fell due to the negligence on the part of the municipal corporation, thereby injuring the various people. The injured people have the right to ask for the suitable remedy in the law of tort. There is a famous case law. I think this is the clock tower case law. Is it Vidyavati versus State of
Sir, in a New Delhi, sir.
New
In a
Delhi?
New
Yeah,
Delhi
yeah, New
municipal.
Delhi, New Delhi. That is
Yes,
Chandni
sir.
Chowk. Chandni Chowk. And
Yes, sir.
there is
That
a
is a
clock
clock tower,
tower.
sir.
It is fell down
Yes,
over
sir.
there, and the municipality has taken the
That is
care.
a negligence of the municipal corporation of New Delhi, sir.
Yeah, what is the name of the
That
case law?
lady, sir.
Can you remember the name of the case law? Even myself. Of course, the New Delhi case law is there, municipality is there, but the first name of the case law that I could forget it. But anyway, that is the case law. Where, yes, it is that is case law which will be very much applicable over there. And there we can say. Of course, here again he have given here Sardar Amarjit Singh Karla versus Pramod Gupta and others, where the Supreme Court held that the maxim UB just UB remedium is recognized as a basic principle of theory, philosophy of law, that the courts have to project and maintain the right of the parties and help them instead of denying them the relief. Yes, again the Bhim Singh already made the state of Jammu and Kashmir a petitioner MLA, and there also it will be applicable over there. Then Shivakumar Chadda versus Municipal Corporation of Delhi, and there also Supreme Court held that various statutory enactment don't provide any remedy, but only creates a right and liabilities in any person complained of his rights being violated, wrongly affected, and such person can approach the civil court based on the principle of legislation where there is a right, there is a remedy. Yes, even the clock tower, if any other institutions, what is edifices which is under the control of the municipality, if it is gone wrong and it fell down and got the injury to any person, naturally that municipality would be held liable, those who are maintaining such edifices or gardens and so on and so forth. So Ashby versus White also qualified. However, because a person has suffered over there, naturally he should be given the remedy, even though it is a nominal damages. The court held that though the plaintiff